Following the alleged misconduct by the Presidential Advisor on Special Operations, John Muhoozi Lugaba, as a UPDF officer, City lawyer Hassan Malema filed a suit against him at City Hall Court in Kampala. The suit filed on 22nd November 2022. Malema alleged that Lugaba addressed a political gathering at Koro Independence Grounds in Kampala without resigning from Uganda People's Defence Forces UPDF, which contravened Section 99 of the UPDF Act that prohibits serving military personnel from engaging in political activities. Although prosecution took over this file on 14th November 2023, Hassan Malema made amendments adding suspects Balamba Lugahale Ateng, Andrew Mujenyi Mwanda, Mawanda Mike, Kabanda David, Nuwagire Mike, Lillian Abel, and Katunji Mike. Before Chief Magistrate Ronald Kaiz of Buganda Road Court, General Muhoozi's legal team led by Fred Mukasambide appeared to proceed with the case. It was, however, impossible following the amendments. In the absence of the complainant, Hassan Malema, prosecution led by Joan Keko asked court to first take the file to High Court Criminal Division for review.
This matter originated from City Hall Court, presided over by a Grade 1 magistrate. It was a private prosecution filed on the 11th of November 2022. On 11th November 2022. Your Worship, the private prosecutor is not in court. The then private prosecutor is not in court. However, on the 14th of November 2022, the DPP took over this case. However, on the 13th of July 2023, the then private prosecutor filed an amended charge sheet plus an affidavit in court, an affidavit in support of his amendment in the same court of City Hall before a Grade 1 magistrate. Yes, and this amendment, Your Worship, just to be, yes, under the Chief Magistrate's Court of Buganda Road. Just to be clear, Your Worship, the amendment added 7 accused persons, to make them 8 accused persons. I refer to the attached amendment received by this court. So on court record dated, added 7 accused persons, A2 to A8. The charge sheet, Your Worship, is on record. It also added 4 counts to make them 6, because the initial one had 2 counts, Your Worship. Yes, Your Worship. To make them 6, because the initial charge sheet had 2 counts. Your Worship, it's our understanding that by the time of filing the amendment, the private prosecutor, as he calls himself, the private prosecutor, as he refers to himself in the documents, had no audience before court. As he refers to himself in the documents, that's the amendment charge sheet and the affidavit. Had no audience, Your Worship, before court. For reasons that, as already stated above in my submissions, that the DPP had taken over this case on the 14th of November 2022. Yes, had long taken over this case of November 2022. 14th November 2022. This filing is on 13th of July of 2023. Your Worship, we don't know the author of these documents to be a state attorney or a licensed prosecutor representing the DPP to file these documents on her behalf.
You don't know the author of these documents to be
employed by the government service as a state attorney to represent the DPP. Neither does he hold a license to prosecute on her behalf. Therefore, he had no audience or locus to make any applications in this matter moving forward. Make these applications to amend the charge sheet, to file an amended charge sheet as he did, on the 13th of July. Your Worship, we would have ordinarily made the prayer before you, before this court. However, Your Worship, Section 50 of the Criminal Procedure Code Act, under Section 50 of the Criminal Procedure Code Act, the power is conferred upon the High Court to correct by way of revision, criminal revision, to correct by way of criminal revision any error. We believe that an error was occasioned by receiving these documents by the Grade 1 Magistrate at City Hall. The receipt of these documents, that is the amendment and the affidavit in support of the amended charge sheet. Yes, and the attached affidavit. We believe that in receipt thereof, yes, we believe that receipt thereof was in error. Yes, Your Worship. And the legal way to correct this anomaly is by criminal revision at the High Court, which has powers under Section 50 to do the same. Yes, Your Worship. In summary, Your Worship, I am saying we now have two issues at hand. We have the initial charges that were filed and taken over, of one accused person and 2 counts that was filed and taken over. Yes, we have two issues that are distinct. Now in court, before you. The initial case that was filed and taken over by the DPP, yes, and 2 counts on the charge on the 14th of November, 2022. Yes, now we have another set of documents smuggled onto the record on the 13th of July, 2023, of July, by a person acting without authority to do the same. It is that second issue, Your Worship, that we want to have revised at the High Court.
I don't need DPP's consent. This is my case. If DPP wanted to charge them, we would have charged them. You see, under the Constitution and the Magistrate Courts Act, DPP has no monopoly to charge people. The private prosecutor can also come and charge people. URA charges people. IEG charges people. So do you think it is DPP who supervises how IEG charges people? That a takeover only happens and only happens when court charges have been confirmed. No charges have been confirmed. We have been there. No, they have not been summoned. And I'm wondering how they ended up coming here, because at the end of the day, all was required was for the court to look into the case, look where there is a prima facie case. After that, issue summons. But no summons have been issued. So what have they been doing here? Yes.
This was not objected by Muhoozi's legal team.
The law allows the court to do so, and that is the High Court, in circumstances where there is wrongful exercise of jurisdiction, failure to exercise jurisdiction, and action, Your Worship, in exercise of jurisdiction that is illegal or materially irregular. The actions of amending a non-existent charge sheet or without powers to do so, Your Worship, majorly by chicanery, Your Worship intends to administer the otherwise very busy leaders of the country and treating them to punitive and reckless bangarang, Your Worship, and attacks. It is in this regard, Your Worship, that we have no objection whatsoever to the application by prosecution that intends to, among others, to offer directory resolve to this matter.
Magistrate Ronald Kayizi granted the application and set 2nd August 2023 for mention of the case.
Also note from the court record that the DPP took over this case in a letter dated 14th of November 2022. The subsequent documents filed by the then private prosecutor, Mr. Mabirizi, on the 13th of July 2022, as the whole court were erroneously received by the City Hall Court. The said documents not only increased the accused from 1 to 8, but also increased the charges from 2 to 6. I note an error on record which I do not have powers to correct, as the same is vested with the High Court under Section 50 of the Criminal Procedure Code Act. I would have exercised my powers as Chief Magistrate under Section 221 of the MCA Magistrate Court Act to send this file to the High Court for revision. However, since the DPP has opted to file a substantive application for revision, it is fair and just that this court gives the DPP time to do so. The State Attorney prayed for a period of 1 month to have this done. I grant the DPP a period of 1 month to file the said application for revision, and the DPP will update this court on the state, or now they are progressing on the 22nd of August 2023. So this matter will be mentioned on that date.
Fred Mukasambide told the media they will defend their clients.
There is an exception where private persons are equally allowed by way of private prosecution to prosecute any Ugandan that is found by the wayside of the law. So clearly, in that precinct, Mr. Mabirizi had filed in 2022 private prosecution against General Muhoozi, which prosecution was itself now taken over by the DPP. The DPP is mandated under the Constitution, therefore, to take over private prosecutions that are administered by private persons. Accordingly, that file had been taken over. But by Buncho and Chikenare, Mr. Mabirizi again somehow magically appeared on the file and amended it to include other persons, including Mr. Balam Barugahara, Honorable Mawanda, and 6 others. This is irregular. He no longer had locus on the file, and accordingly he could not amend any. Despite even the fact that the amendments were themselves laughable, because he chooses, therefore, to try Mr. Balam Barugahara and Honorable Mawanda and others under the UPDF Act, to which they are not subject. So you find that it is actually extremely inconsistent, and that is what we refer to as majorly tumultuous and treating very serious leaders to bangarang. Persons that would actually be progressing, combing the nooks and crannies of the country over how we must move on, being treated and introduced to laughable trials here before courts of law. So the first step that we took when we got instructions was to make sure we apply to the Chief Magistrate in order to take over that file and remove it from the KCC court under the directory and, of course, directive supervision of the Chief Magistrate's Court over the subordinate courts. The file was accordingly transferred from the hands of those that recklessly agreed upon the files and what we would call frolicsome ludic by Mr. Mabirizi. So the file was introduced here, and on account of this, prosecution has presented under Section 50 to the, of course, Criminal Procedure Code Act that the High Court is the only mandated court to erase the irregular details that had been otherwise put on record. So, meaning that the High Court is going to perform the duty of erasing all the other accused from the charge sheet, and accordingly, General Muhoozi will remain alone, but still under the prosecution by the Director of Public Prosecutions. That is the kind of reference that we have received, and I think we did not have time and even audacity to generally object to the application as prayed for. I still have instructions to continue. I have not been stopped, and accordingly I can let you know that it is one of those cases referred to as majorly frolicsome and vexatious. They cannot see the light of the law beyond even one day when it appears.
Just like you have been told, the case lodged against us by Honorable Mabirizi, it is more of comedy. So it's a comedy show because the case had been taken over by DPP. So Mabirizi went using his backside means. They went and picked the file. He got a rubber and they erased the names and added our names. It's an irregular practice. So I'm really surprised. But as a brother to Mabirizi, I will look for Mabirizi and ask him, what is your problem? So I've seen him around. I want you to ask him, what does he want? I'm willing and very much ready to ask the president to appoint him as RDC in Rakai. Yeah, so that he gets some work. That is it.
The complainant Asani Malemabiri's after court also arrived at court. However, he was dissatisfied with the way court has handled this matter.
You see, I opened up charges against 8 people. Muhoozi Kainerugaba, Mawanda, Balamu, Katunji, Lilian Yaba, David Kabanda, all that group of theirs. Initially, it was against Muhoozi. But on Thursday, I amended the charges, using my power as a prosecutor, and added on these other people. Now, the case was fixed for stay whole court at 2 p.m. today, 17th July. When I arrived at stay whole court around 10, the magistrate tells me their letters here, the file was taken. I get information that actually this chief magistrate, Kaizi, moved to stay whole court, picked the file from there, came with it. Minutes later, I wrote the letter saying that he has taken over. Now, Kaizi made misconduct, and I'm going to take him to the service commission. Because a magistrate grade 1 has powers to hear any case other than that where there is life imprisonment. The highest sentence in the charges I'm charging them for conspiracy to commit a misdemeanor is 5 years. So the magistrate still had the powers and shall not complain that she doesn't have the powers. So because it seems these people have their own connections, maybe the magistrate at Stay Hall was not in their connection, they picked the file from there. Now, to make it worse, before the magistrate at Stay Hall, the time agreed upon was 2 p.m. It was 2 p.m. That's what she wrote in the diary. Now, this chief magistrate says, calls the matter at 9. So at 9, I wasn't here. So she conducts a hearing in my case, in my absence. He is told that Simani there was a takeover. There cannot be a takeover. The DPP issued a guideline, a circular. I have it here, in 2021. Making it clear that the level of takeover is when charges have been confirmed by the court. It is so clear, it's in black and white. So there is no way State House can claim to take over a matter before charges have been confirmed. She was doing these things before, in 2020. But now Abodo clarified that no, you only take over when charges have been confirmed. So there's no takeover. Therefore, I had the powers to amend the charges, and I amended the charges. So you cannot hear my case when I'm absent. You claim that you're hearing my case when I'm absent. And that chief magistrate, my complaint or my case has my contacts. Was I contacted? Was I served with anything? So how could he proceed in my absence? So he did misconduct, and I will take it on him to service commission apart from High Court. Because if you don't take them on, they will think that it's okay for them to come and make noise around. So those guys are still parties, and I'm going to go to High Court to ask for the High Court to nullify these fake proceedings, because you don't proceed in my absence, especially when I'm a private prosecutor. I slapped 60, actually there are 6 counts in total. About 4 of them are against Muhoozi individually. That is conduct prejudicial to good conduct of UPDF, common in nuisance, and the breach of statutory duty. They all emanate from Section 99 of the UPDF Act, which is clear that a serving military officer cannot come and participate in politics without retirement. Now, this very case happened on 10th October, where they held and made political statements. Now, all these people are charged with conspiracy because they are all there. At that time, they made noise, they did what, and they did what. So those are the charges, basically. The highest sentence it carries for conspiracy is 5 years. That's why I was saying that I don't know the rationale this chief was using to call the file. Because a magistrate grade 1 has powers to hear any case apart from life imprisonment. So those are the charges.